Syllabus is also provided. The next page. Object to that, paper 1 of paper 2. And then we go to the main examination. Main examination is not relevant. That's what we present. So what's first time? They conducted an examination. The preliminary examination was in the first earlier. After the examination was over, similarly notes we had received objections, notes, and complaints with regard to translation errors. At that stage, the KPSC notes had constituted an expert committee, and expert committee had given its reports. Based on the report, the commission had taken a decision that it is a fit case for holding the examination. In the meantime, parallel, it also happened that the chief minister had tweeted that the KPSC will be conducting the re-examination. And on the basis of some meeting proceedings, there was a chief secretary's note also sent to the KPSC to hold a re-examination. Matter was challenged notes from the Harvard bench of the High Court. The main contention was KPSC is a constitutional body. The decision to hold a re-examination should be of the KPSC. KPSC cannot abdicate its decision-making powers to any authority, much less the state government. Intermodal notes are initially granted. Thereafter, the matter was solved. We were able to demonstrate notes before the court that whatever we received from the government was in the nature of an input. On the basis of that, it was an independent decision of the commission to hold a re-examination at that stage. And thereafter, notes the state got predicted, the matter is still pending, final order is not been passed. So therefore, I don't have the decision to cite as that. Then thereafter, notes 29, 12, 24, we have held a re-examination. Now, after the re-examination was held, there were again certain complaints with regard to translation errors. And after the provisional key answers were published on 15/1/2024, there were also certain objections received with regard to other aspects, with regard to key answers. Now, on the basis of the complaints that were totally received, or objections and complaints, I will call it which were also forwarded to the state government, plus we have constituted an expert committee. Expert committee, no, so far as we are only on translation, because the entire case is on translation. Apart from translation, wherever key answers, there are on technical issue where the question itself was ambiguous in such a way, response have been avoided. I will come to that. I will demonstrate. I will show that. But on translation errors, kindly note, in paper 1, there were complaints about 32 questions having translation errors in paper 1. In paper 2, there were complaints about 29 questions having translation errors. So totally towards 61 questions, there was a complaint or an objection that there is some translation error.
In paper number 2, 29.
Total like 61. In respect of the 29 questions, there is no translation errors. So no further action is required on that. In respect of paper 1, they have stated in respect of 2 questions, there is translation errors. So they have recommended for grace marks. And in respect of 1 question, in view of the translation error, the key answer was changed. And the key answer was made to 3 answers being correct for it. So this is the decision that the commission has taken on the
paper 1. Only 3 errors found.
3 errors found. Otherwise, 2 errors grace marks recommend matter. All recommend matter. Just for the 1 error notes, they said the key answers will be they have changed multiple key answers. Now, I had touched on the final revised key answers. One sheet was passed on those. First, I point out which is pertaining to translation error. That is it. Whatever I'm relying upon, you don't compare to my separate.
Yes.
But this is dated 3/2025 from the publication. But this is the final revised key answers after consideration of all the objections. But my last again is see in paper number 1, serial number 2. That is, because I'm referring because we have 4 series of question papers, but question number will be with reference to series A series as well. Otherwise, kindly see was serial number 2 relates to A series study question number 21. So that we have given grace marks. This is also expert committee recommendation. And serial number 7. Question number 94. Grace marks. These are the 2 questions with respect to which that our experts have opined that there is translation errors and they have recommended grace marks.
Serial numbers
2 and 7.
2 and 7.
2 and 7. Question number 1. Then there was serial number 4 earlier. The key answer has been revised. It was 2. Now they have said key answer 2 or 3 or 4. This is also because of some translation ambiguity. So this is also the recommendation of the expert. Apart from this, if I lost the notice, paper 1 only serial number 5 we have a Kupanga. Paper number 2 only we have serial number 4 and 6 also Kupanga, grace marks. But they don't relate to translation errors. They are in respect of other aspects of other technical aspects of where the experts have opined with regard to grace marks. Since we are only on translation, and I had pointed this out with respect to these question numbers also on the last day when I had cited this notes or 2 or 3 days back with other. And this document that I am placing before my lords is what was published to the KPSC. And it is on the website also. Submission is this. As a recruiting body, it has come to my notice. Now, what is the decision-making process that is expected of me? What's the key answers not are provided to the question paper sequence?
The only question is that according to the KPSC, only there were 3 errors in translation in favor of
What the expert will
that has been separated by getting experts' opinion by giving grace marks. According to the submission of the learned question for the applicant, based on this reply of the Honorable Chief Minister in the floor of House, there are more than 58 errors in the translation.
Because the state can also place the official answer. I didn't believe it. Not dispute about that. On what basis not the statement was made. In fact, I wanted to consider that.
But the opposition party leader has given details about the 58 and 78, but based on the Chief Minister not denied it. Denied it.
What
But
is
Get into the expert.
experts.
because in fact, in the Times of India, the learned friends have cited to Kannada papers notes. The Times of India just only one shot because there was so far as KPSC is concerned, the discussion on the floor of the House is with regard to this recruitment. One thing. Second thing was we have an AW recruitment process that is going on. There were not happening. Function subcommittee itself had recommended was that appointment process should not be done. That matter is seized out before But that also was discussed. In the meantime, when the court also was concerned
The
about
question is how to ascertain whether the say of the KPSC pertaining 3 questions is true or the say of the applicant, sir.
that is our notes by judicial precedents. I will take my lots to certain judgments, including the judgments cited by them, which show either in this kind of circumstances what is the approach of the court. What is the approach? But insofar as the statement made of the House, I'll just read notes what the Times of India has reported. On the demand for a re-examination, for clarified that the government cannot interfere as the issue is pending before the Honorable Karnataka Appellate Tribunal. If the KIT agrees to the re-exam, that means if this Honorable Court, after hearing the matter, decides that the government will have no objection to hold, that is what is the statement that is made. If it refuses the fresh exam, then I will discuss options. That is what it says with the chairman. However, the sentence are in our particular time selection. However, with the KPSC, as it is a constitutional body, this is the statement that is made. They have been very much guarded in so far as making submissions because it's a constitutional body. Though not the state government is a stakeholder because it is your group and grouping post, no doubt about it. But not the statement of the notes, I was informed that on the last date of hearing when Mr. Bharat this is the stand of the state. Let them officially also make that stand. In view of the fact now that that's maybe if not the recollect how the legislature was trying to, maybe they were waiting for the some statement to be made on the floor of the House. I can gauge that. But maybe Chief Minister could not make it for 2 days because of self-condition was not available in the House. Then finally, I think at the right time they got that statement also that was made. They were able to produce it. But at the end of the day, I will make my submission because even the Chief Minister said KPSC is the constitutional body and the final decision rests to the KPSC. This is what the claim. And in case the AG or whoever is appearing for the state, in case the court calls upon the AG, also can appear as informed. Then whatever statement has been made, whatever is the official stand of the state. Earlier, last time one tweet created and one meeting proceedings in fact created a case where it is the other way around. KPSC has to take an independent stand. KPSC cannot abdicate its functions to decision-making process towards to the government. It is settled off. In fact, I will cite a judgment where, with regard to the role of the KPSC, there was one order notes passed by the KSC. Government accepted that order. And the Lords decided not to challenge it and decided to implement it. KIT decided to file a petition against that order. In the High Court, when other petitions also were filed, it was a batch matter. The main issue, one of the questions that was decided was when the government, in respect of, has accepted the can the KPSC have locus to challenge it? And the findings, I will read those findings, show that what is the status of the KPSC, constitutional body, to what extent can government issue instructions, to what extent it is bound by it. And finally, the court has said KPSC is locus. KPSC is in so far as from the time I receive a requisition till the time I send my final select list. It is my decision making that is being questioned. Whether the government questions it, whether the honorable tribunal questions it, we are supposed to answer. If they cannot say that let the KPSC not answer, let the government take a decision. That the main stakeholder is kept out. And you want the other people to take a decision. That is not how it goes. In fact, the government is conscious of that fact and said KPSC is the constitutional. If the court decides, we will say that is what they have said. And in fact, because the matter is this, and they have not said anything about the present matter. So therefore, there is no impediment for the matter to be heard. Certainly, they have raised a condition. It is so the government must let them officially so that there is clarity. Because this answer should not be left because they have raised it. The Lords have to say something about it. So the government will say that to us. They can take instructions to say that because they have said so. Now, Lords, coming to now. My respectful submission is, I will also not place on record the expert opinion. That is not going to the question. Yeah, question is reasonable. And the court
we want to see please, which questions were referred. Impugnant means disputed questions were referred to the expert committee. Please. 61 questions. And how they have come to the conclusion that the so and so translations are right, correct, and so are not correct. On what basis they have taken such a such a decision that these are not correct?
that will be placed.
Other,
And the
other,
certificate
if now that material has been supplied, certainly it will assist to the people to come to the right conclusion.
You want that expert class.
And court can take judicial notice as to which is correct or not. To go to the English and Kannada, we can take a judicial note, no problem.
the experts and all about them, that's also supposed to be placed upon my notes. Because they
What is the expert, then the expert.
And
And
then
the judge.
yes, I
Expert really there.
Yeah.
What is the expert, then the expert is as per the decision of the.
I will place the report for substantial.
You can just say the process. We like to see the process.
Yes, the decision making process is what is actually subject matter of judicial review. The decision itself, not in some cases, I'm not saying that the decision is not, but I will come to that. But what we are saying is, this is the process I have adopted. This process I adopted last time. I held a exam. That was the decision of the commission. This is the process I have adopted now. I have accepted the report of the committee. Now, because if the commission had found like last time, they had stated more that one statement was made by the learned senior friend that in so far as the degree of mistakes was higher. In fact, as per the expert committee report, last time was the degree of mistakes was higher. So therefore, it was a decision taken by the commission. By giving grace marks, I can go ahead with the process. Therefore, the decision was taken by the commission to accept the expert's committee report. Now, only for 2 or 3 years, the whole re-examination we held notes is another question. I will say what the course has said on this and what is the scope of judicials. Coming to the main issue of the applicants. Now, before my lords, we have 3 applications. In one application, we have 52 applicants. In second application, we have 24 applicants. And in third application, we have 3 applicants.
52, 28 and 3.
52, 24 and 3.
24 and 3.
We have just made one tabulated statement. But we are just passing that. Finally, once I'll make one more copy and give the one with the manual. But just for reference. They are claiming that we are Kannada medium students. So there could be notes. Here, the question of notes a Kannada medium student does not arise because in the question paper, in the application, you don't declare that you are a Kannada medium student. The only indication could be that you are claiming a KMS reservation, Kannada medium student reservation of birth. That's one now we have indicated there. If they are claimed, so kindly see notes. Who are the applicants here who are coming for? Immediately, they are not qualified for the main examination. So maybe they want one more attempt. So therefore, they are trying to they are filing these petitions. Now, whether they had a real grievance with regard to the translation errors has to be looked into. Now, what's the first page of it? Kindly see this. And just to say, rank of the party have given who is the applicant and whether he has claimed KMS reservation or not. He has not claimed KMS reservation. But that will not, I can certainly say that will not say that he is not a Kannada medium student or something. But can you see his educational qualification? He is civil, MA journalism and mass communication, and his service details. These are all notes I have only culled it out from the application produced by them in the original application. Service details. He is a junior engineer in a private organization.
Since he is so qualified, he could find out the errors. No?
Please, boss.
Since he is so qualified, he could find the errors.
No, there is
But the error is there. It's just for me to investigate and find out that.
no. What they are saying is because of the error,
I could not.
I was not able to answer the question. That is the case at the end of the day. And therefore, my equal opportunity guaranteed not under the Constitution is lost out. Because at least the process has to be fair as to what is the case. Now, we have also notes BA, MA English graduates also in this list. So next question, my lord, says, how many of you filed objections before the KPSC? Well, in the last page, I have stated that the applicants in none of the cases filed their objections to the key answers as final application paper book. They have not even pleaded that. Only applicant number 2 in application number 686 of 25 has produced his objection subsequently by way of a memo of 324. The date of the submission of his objections is 21/1/2025. He has objected to a total of 4 questions on translation related issues. So, Lords, I will find out judgments. That the consideration was with regard to erroneous questions is based on the pleading of the person who comes to court and says, this question was like this. It was ambiguous, I could not understand, I did not answer. If I had answered it, if it was correct, maybe I would give it consideration. That is the pleading that has to come. No, their entire argument, in fact, all the counsels who have argued, was not, they did not argue their case. They wanted to directly attack my statement of objections. Give this legal advice on how a statement of objections has to be drafted. Say, notes this fact. First, you have to set out that I have this was a question paper. This is the series. In this series, this is the question. The applicant has to say, I did not answer. This is prejudice my case. There is no pleading to that. There is no argument regarding that, and that is where the Supreme Court has interfered in matters notes where key answers notes are going to be called with.
Tell us one thing.
Please notes.
Only one applicant has objected to 4 questions. Then where this question of number of 59 errors came?
No,
Where this number came from? That 59 numbers are 61 numbers are 30 translation.
We have this
Only one. You have.
So this is from the applicant's
No, I'm saying here you are saying only 4 questions were put in the
by
question
one of the
by one of the thing. The rest all have not given any.
no, applicants.
By applicants.
By
But otherwise, you have received.
I have received notes.
Only applicants in applications from KPSC.
You have received 59.
61 objections regarding 61 questions. On translation, can you note this? On other aspects, there could be other things. On translation, paper 1 and 32, paper 2 and 29 questions per year. It is not the number of objections. It is objections regarding the number of questions. Because one candidate, there could be 3 objections on 1 question. So totally 61 questions per year. And so 61 questions were placed before the expert committee with regard to the allowing the objections to give their opinion. In so far as, so therefore my respectful submission is the basic, they have not discharged the basic burden that they are supposed to discharge with regard to the fact that number 1, I am a present medical. If I even answered that this is the number of marks I would have got. If according to him, if according to one applicant, there are 2 questions that he could not answer. He should say whether he attended or not. See, there is, and because I did not understand, ನಾನು ಅಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ತಪ್ಪಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಬಿಕಾಸ್ ಕ್ವಶನ್ ವಾಸ್ ಆಂಬಿಗ್ಯೂಸ್ ನಾನು ಅಟೆಂಪ್ಟ್ ಮಾಡಿದೆ ನನಗೆ ನೆಗೆಟಿವ್ ಮಾರ್ಕಿಂಗ್ ಹೋಗ್ತಾ ಇದೆ ಅಪ್ಲಿಕೆಂಟ್ ನಂಬರ್ 1 ಗೆ 4 ಕ್ವಶನ್ ನನಗೆ ತೊಂದರೆ ಇದೆ ಅಪ್ಲಿಕೆಂಟ್ ನಂಬರ್ 2 ಗೆ 5 ಕ್ವಶನ್ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಮೈ ಮಾರ್ಕ್ಸ್ ಇಸ್ ಆಲ್ಟರ್ಡ್ ಬೈ ದಿಸ್ ಐ ಆಮ್ ನಾಟ್ ವಿತ್ ಇನ್ ದ ಕಟ್ ಆಫ್ that should be that if that pleading were there then I could straight away answer my lords whether based on the OM sheet my lords could have answered but LDC not that pleading they are ultimately saying it is not a public interest litigation. In service matters, periods are not maintainable. Secondly, notes it cannot be taken up before this tribunal. They have to go and file a petition before the Honorable High Court on that. So therefore, and one submission was made by my learned friend, it is not adversarial in nature. Certainly, notes I would say that as a public service commissioner, I am certain, in so far as the court in the public service commission is concerned, we are supposed to answer everything because the credibility of my examination process is at stake. But that does not mean that you come every area just random objections and expect the court to answer. I would respectfully submit that the basic pleadings that are required to be made have not been made in this case. And from their educational qualifications and their service details of some of them, I fail to understand more how their argument with regard to the fact that because question was in there was ambiguity with regard to Kannada, I could not answer because the question was always available in English and there is no dispute in so far as the applicants is concerned with regard to English question is concerned? The application number 285, yeah, in any question, the application number 285, page number 171 is that. And it's a- Wait. 171. Okay, this is one question paper. What's one question paper? Okay, listeners, at 171, bottom of the page, I have given instructions. Bottom of the page from the English version of the instruction is printed on the back cover of this question paper. I'll take on to the English version, which is the page number 226. And this is instruction number 7. Questions are printed both in Kannada and English. If there is any confusion in the translation of Kannada questions, candidates shall refer the questions in English and understand the questions.
Question number, the instruction is
7.
We do this instruction in Kannada.
It is the same with 7. I just read it in English. It is at 171. 171 Kannada is serial number 7. Same thing. Yours in English question also is 18 may kind of see. Penalty for wrong answers. And this is relevant to us because I have to answer one other contention. Penalty for wrong answers. There will be a penalty for wrong answers marked by the candidate. There are 4 alternatives for answer to every question. For the candidate, 1/4 of the marks assigned to that question will be given to this penalty. If a candidate gives more than one answer, it will be treated as a wrong answer, even if one of the given answers happens to be correct. And there will be the same penalty as above to that question. If a question is left blank, that is no answer is given by the candidates, there will be no penalty for that question. Can we note 3 also? If a question is left, no penalty for that question. I will come to this notes in so far as why grace marks is given to all irrespective of attempt. When marking is there, it shifts. When negative marking is not there, attempt matters. But when negative marking is there, notes how the attempt will, whether it is attempted or not, will change. Notes the underlying principle of fairness. That is first. Now, notes kindly see page 171 also has instructions in Kannada. 171 first page. Now, my lords will kindly see 172 and 173. How the question papers have been, how the questions are printed. 172 is a Kannada version. One side is Kannada is the same questions are on the right side in English. So it is not that you have to go somewhere to refer to an English question or to a Kannada question. Left of the page, Kannada question. Right of the page is an English question. So therefore, question number 1 is available there itself. Kannada question as well as an English question. So it is not that you have to flip like another 30 pages to go to English version and flip back another 30 pages to come back to English version. So now, so far as answer is concerned, he just has an OMR sheet. OMR sheet only, he just marks what's the option. So therefore here, whether you read, now nobody can go back and say whether you read the questions in Kannada or you understood the questions in Kannada or in English. Nobody can say. Now there is an argument that we are all Kannada medium students and all these things. And even in that notes, now it could be that a person has studied degree in notes in English. But if it's a technical degree and other things notes, it is unlikely one thing. If it is any other arts degree and other things, there could be a chance. Now they have to declare themselves that I have attempted in Kannada. ನಾನು ಕನ್ನಡದಲ್ಲೇ ಓದ್ಕೊಂಡು ಬರ್ತಿದ್ದು ನಾನು ಇಂಗ್ಲಿಷ್ ಓದಕ್ಕೆ ಆಗಿರುತ್ತೆ ನನಗೆ ಇಂಗ್ಲಿಷ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ. But they cannot do so because the minimum qualification that is required to be selected to a group A and group B post need to be proficient in both the languages. And therefore, notes by respecting submission is, since we have already, this very same condition was also interpreted by the Supreme Court in the Rangarajan's case, which my letter friend has led, and he had also stated that I will be relying on that, I will rely on that. And Supreme Court said, because this clause is there, ambiguity is there, but that was the case notes where it was with regard to its entrance, or maybe notes PG entrance to MBBS, and the court had held that because you have an undergraduate course notes which is usually held in English because it's a medical course, so therefore the no prejudice would be caused. So my submission note says that in the light of the fact that there is a condition notes in the question paper itself, that if there is ambiguity, you refer to the English version, unless they are able to demonstrate each of the applicant. Now, he knows what he has answered. He has a carbon copy of the OMR. ಯಾವ ಕ್ವಶನ್ ನಾನು ಏನು ಅಟೆಂಡ್ ಮಾಡಿದೆ ನನ್ಗೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು ಅಂತ ಹೇಳಬೇಕು. You cannot just come notes and ask for a re-examination. It has drastic consequences. Notes, notes in a complete examination. At the end of the day, notes only pure selection, and it is a process of elimination. There will always be notes hard won, and there will always be unselected candidate. So therefore, notes litigation will not. So. Expert opinion, because on how the expert opinion, if an expert opinion is there, there was a case notes where after an expert opinion, the High Court felt in like question no. High Court, in fact, and in some cases, notes incidentally, the question notes was on law. So court said, okay, in that eyes of body or something else, could you have read that question or gauged it? So therefore, expert opinion matters. My respectful submission. Okay. Towards the first judgment, I want to cite is notes Rangarajan's case, Speaker Rangarajan.
Last chance.
Because they have already cited, if it is not ready for the sensory possible, then it says
2019, 12 and 15.
I have extra copies for the court.
Rangarajan with the memo dated 10/3/25.
Yeah,
Memo I can have to be fish.
Because there are 3 cases in this.
We touch that.
Because but the context of the there are one
Page 678. Internal page number 6.
Correct. I'll just read this. Some of the examples of the discrepancies in translation which occurred in the Tamil version are as follows. In the English version, there is not the incorrect option for the following set of examples for divergent evolution. Forelimbs of man, bat and cheetah, heart of bat, man and cheetah, eye of octopus, bat and man, brain of bat, cheetah. If one has a look at actual discrepancies in the questions that were said to have been that are said to have created confusion, it seems that the word with the imprecise meaning could have been easily discovered to be faulty, and a simple reference to the English version would have clarified the same. A simple reference to the context in which the imprecise word occurs in Tamil version shows that the word could not have that meaning at all, and there was obviously some mistake which needed to be removed by reference to the English version. 14. According to response number 1, in the Tamil version, the word cheetah is translated as Sita. Now, it would be obvious to apply the common sense that Sita, which is the name of the goddess, and used for human beings, cannot occur in the example for divergent evolution of man, bat, and cheetah, etc. This mistake in cheetah appearing as Sita is said to because of mispronunciation of the word Chutian as so and so. Similarly, the word has been translated as so and so. It seems to be a result of mispronunciation. Likewise, it was pointed out that in respect of translating ragam, which means variety, in Tamil, that a plain reading sounds absurd, but it would be obvious to anyone that the The question deals with the variety of rice which was patented by a foreign company simply because there cannot be a name of rice. The errors were so factual and could have been easily answered by referring to the English version. 15. We may not be understood to be taking the view that mistakes in translations which give a disparate meaning should be allowed to appear in question papers. The translation must be accurate. We are informed that from the next academic year, 2019-20, the NEET examination will be conducted by the National Testing Agency. The society set up by the government of India to identify conducting examination for grant of admission, etc. The NTA is established to ensure that the methodology of translation to conduct the examination is improved. In order to make it improved, it is proposed that the translation will be done by subject experts who are proficient in both the languages, that is the source language and the target language. 16, he has read the verse, I will read it. This is in the context of what directed the NEET to do. Translation will be done from the language to the source language and back to the target language. Thus, for example, a question in English translated in Tamil will be translated back to English. This dual translation approach will remain a chance of ambiguity in the question paper. In spite of this safeguard, it is proposed that in case of any ambiguity between a regional language and English version, which will be final, as held by this court in the order dated so and so referred to above, we find that this last mentioned clause is extremely significant, that is English version is final, to ensure that the students have some basic knowledge of English, even if they are allowed the facility to write the examination in the regional languages. Presumably, this is because the entire education for MBBS, BDS courses throughout the country are in English. It was assuming that there was some justification in the plea that students were prevented from understanding the question, and we find it difficult to sustain the remedy provided by the High Court. The number of students that appeared in NEET so and so was 13 lakhs all, approximately 10.5 in English, approximately 1.5 lakh opted for regional languages, and of these nearly 24,000 candidates took the examination in Tamil language. Because of a mistake in translation, which could have been detected by that all the students across the board who took the examination in Tamil have been awarded for all the 49 questions without any reference to the answer to those questions. The consequences is equally unjust and unacceptable as the students who gave the examination in Tamil have been unduly benefited only because they opted to give examination in Tamil. It is said that there are some students who might have otherwise failed, but for the addition of marks by the High Court, most of the students have secured higher marks than those who gave the examination in English and other regional languages. This is mainly due to the blind allocation of 196 marks to every student who gave exam in Tamil. Then he reads 19 marks, Guru Nanak Dev. In so and so, in somewhat similar circumstance, but the CPSC opined that 10 out of the 21 key answers were incorrect. This court called for a report from CPSC and Delhi University as regards correctness of those 10 answers, and thereupon, in order to preserve merit, the court directed the university to reevaluate the answers to the opposite 8 questions with reference to the key answers. This course adopted by this court was to prevent arbitrary awarded marks. We see no attempt to improve judgment to have the marks evaluated by independent expert bodies. Instead, the High Court resorted to blind allocation of full marks for each of the questions. Can you notice this? We see no attempt in the improved judgment to have with the sorters. In fact, in Guru Nanak Dev University case, wherein this court found that in respect of rare questions which are incapable of correct answers, the university could not have given credit to those questions to all the students, irrespective if the question has been attempted or not. Even so, by the improved judgment, the High Court has made no attempt to see whether students have in fact attempted answers to the questions which are claimed to be imperfectly translated, and has proceeded to award the full marks of 49 questions to all candidates who have opted for the examination damage. The method adopted by the High Court is manifestly arbitrary and unjustified and cannot be sustained. The list of students who opted to give NEET 2018 examination in Tamil after the addition of 196 marks is startling. For instance, the student who got 260 marks has been awarded a total of 456 marks. The student with 137 marks will be entitled to 233 marks, and a student who got 92 marks will be entitled to 288 marks. Even students who have 21 marks have been entitled to 217. It is clear that the High Court law said that the primary figure of the court in such matters that is to avoid arbitrary results. This judgment was cited for 2 things. Number 1, para 16, he says that court had directed how translations have to be done. But that was in the context of para 15, where from next year court had said NEET exams NTA ಮಾಡಬೇಕು, NEET translation ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. That is what is the context. It was not a general direction in paragraph number 16. Then thereafter, awarding of grace marks was also based on Guru Nanak's. It has been urged by this honorable court, before this honorable tribunal, that awarding of grace marks, irrespective of the fact whether it was attempted or not, is something. Notes, I am making the statement notes that so far as grace marks is concerned, it will be given to every person whether it is attempted or not. And I will justify notes that that is the right decision in this case. Firstly, notes in the case at hand, English language, there are 14 regional language papers. In that case, English was the language. Apart from that, there are 14 regional language papers. Terminally translation error, ಬೇರೆ language alagadu. So, and it is conspicuously absent with regard to the negative marking. So therefore, giving negative grace marks to all the candidates irrespective of the attempt notes was found faulty by the Supreme Court. Here, kindly note notes, since the question or the translation itself is of such nature, question at the good Porata marks model, let the grace marks code. And I'm giving it to everybody because the negative marking here. If the question is ambiguous, there is a confusion, attempt madilla anta helidre, then again it will be unfair to the person who was attempted. So therefore, even in Gurunana's thoughts, what the Supreme Court said was, where in fact it is without it being evaluated by the independent expert, I could directly awarded full marks. That was found faulty. So therefore, that is notes in para 19 and the last 3 lines 11. So therefore, in my respectful submission, the law that has been laid down by us in Gandhadagud's case, number one, I am relying on the fact that if there is ambiguity between two languages, English language prevail agbekanತ question paper condition idre. So that will take care of any ambiguities is what is the view of the Supreme Court. So therefore, this judgment notes in fact covers my case because I have notes condition number 7 that has been set out in the question paper is specific that if there is ambiguity, please refer to English. Please answer with reference to the English question. Judgment and citing.
So the correct question, was there any complaint?
That is
The other
other
question, no, was the other question, the question itself was wrong. Was it a-
Yes, that's what it is.
No, translation ಅಲ್ಲಿ mistake ಇತ್ತು ಅಷ್ಟೇ.
ಇದು translation and mistake ಉಂಟು. We have
3 questions.
61 questions. 61 ಅಲ್ಲಿ we found 3 grace marks ಕೊಟ್ಟಿದೆ. Apart from this, I had other complaints also. Question itself is wrong. Question is that for that also because I have there are other grace marks.
This is not pleaded.
That is the issue. The applicants are not they are not an issue on that.
Just to clarify, we are on it,
But
leading with the different.
yeah, it was marginal.
Yeah, just for clarity, just for
ನಾನು reply
it's like ಕೃಪಾಂಕ ಕೊಟ್ಟಿರೋದು ಈಗ
ಫ್ಲೋ ಆಫ್ ಥಾಟ್ಸ್ ಕಟ್ ಆಕೈತೆ ಅವರಿಗೆ ನೀವು ಆಮೇಲೆ ಹೇಳಿ ಆಮೇಲೆ ಮತ್ತೆ ಅದು ಎಲ್ಲೋ ಟ್ರ್ಯಾಕಿಗೆ ಹೋಗ್ಬಿಟ್ಟೈತೆ
ಅಲ್ಲ ಕೃಪಾಂಕ ಕೊಟ್ಟಿರೋದು
ಆಯ್ತು ಆಯ್ತು
Was kind of see with judgments 2021. 28309. Para 3 minutes, set out the facts. But in my respectful submission, the fact situation is almost similar here. Para 3. I'll just read notes, para 3. For the sake of convenience, for the sake of convenience, we refer to the facts of the appeal arising out of SLP number so and so. An advertisement was issued by the Rajasthan Public Service Commission on 13/7/2016 for selection of 9,551 senior teachers grade 2 in social science, Sanskrit, English and maths. Written examinations were conducted on 1/5/2017 and 2/7/2017 in general knowledge and social science respectively. RPSC issued the first answer key on 6/2/2018 and declared the results. The names of the petitions were mentioned in the list of selected candidates, but they could not be appointed due to certain defects in the detailed forms filed by the petitioners after the selection. On 25/4/2018, single judge of the High Court of Judicial of Rajasthan, Jaipur bench, referred 3 questions in the first answer key to be reconsidered by an expert committee. Shortly thereafter, a single judge of the High Court of Judicial for Rajasthan, Jaipur bench, referred another 8 questions for reconsideration by an expert committee on 5/2018. An expert committee constituted by RPSC revised the key answers for 2 questions in social science and 1 question in general knowledge. The revised key answer, which shall be referred to as second answer key, was issued pursuant thereto, and the merit list was also revised 17/9/2018. The names of the petitioners were not included in the revised merit list. The judgment dated 5/2018 of the learned single judge of the High Court of Education for Rajasthan, Jodhpur bench, by which 8 questions were referred to the expert committee for reconsideration, was the subject matter of appeal before a division bench of the High Court. The grievance of the appellants therein was that they have challenged the correctness of 33 questions, which required to be referred to the expert committee. The High Court examined the correctness of the disputed questions by itself and of this course, and came to a conclusion that the answers to 5 questions were wrong. After being informed that the results have been announced and the selection process was completed, the division bench of the High Court judgment dated so and so and DB special so and so directed revision of the select list and give benefit of the revision only to the appellants before the court. The appeal arising out of SLP number is filed, questioning the correctness of the judgment dated 12/3/2019. Now, let's kindly see para 13. So before I say para 13 notes, I'll just say, notes here, High Court had referred the first key answer that was published to expert committee. There was a secondary revised key answer based on the expert committee report.
Appears that before constituting the expert committee, you are by relying this judgment, you are constituting the committee.
Then division bench, what it does is, expert committee secondary, they themselves find some translation errors and say, you go third revised key answers. Now, what the Supreme Court says, para 13. The point that arises from the consideration, para 13. The point that arises from the consideration of this court is whether the revised select list dated 21/5/2019 ought to have been prepared on the basis of the second answer key. The appellate content also should be prepared on the basis of the third answer key and not on the basis of the second answer key. The second answer key was released by the RPSC on the basis of the recommendation made by the expert committee constituted pursuant to the directions issued by the High Court. Not being satisfied with the revised select list, which included only a few candidates, certain unsuccessful candidates filed appeal before the division bench, which was imposed upon so and so. When the division bench was informed that the selections have been finalized on the basis of the second answer key, it refused to interfere with the select list prepared on so and so. However, the division bench examined the correctness of the questions and the answer keys pointed by the appellants therein and arrived at the conclusion that the answer key to 5 questions was erroneous. On the basis of the said findings, the division bench directed RPSC to prepare the revised select list and apply it to the appellants before it. Okay, though revaluation can be permitted if rules can be directed if rules permit, this court has deprecated the practice of revaluation and scrutiny at the question by the courts, which lack expertise in academic matters. It is not permissible for the High Court to examine the question papers and answer papers itself, particularly when the Commission has assessed the implicit merit of the candidates. The court should have shown deference and consideration to the recommendation of the expert committee, who has expertise to evaluate and make recommendations. 15. Examining the scope of judicial review with regard to revaluation of answer sheets, this court in Gandhadagudi was the state of UP held that the court should not revalue or scrutinize the answer sheets of a candidate as it has no expertise in the matters, and that academic matters are best left to academics. This court in the said judgment further held as follows. On our part, we may add that sympathy or compassion does not play any role in the matter of directing or not directing revaluation of answer sheet. If an error is committed by the examining body, the complete body of candidate suffers. The entire examination process does not deserve to be derailed only because some candidates are disappointed or dissatisfied or perceive some injustice having been caused to them by an erroneous question or all candidates suffer equally, though some might suffer more, but that cannot be helped since mathematical precision is not always possible. This court has shown one way out of the impasse: exclude the suspect or offending question. It is rather unfortunate that despite several decisions of this court, some of which have been discussed above, there is interference by the court in the results of examinations. This places the examination authorities in an unenviable position where they are under scrutiny and not the candidates. Additionally, a mass sometimes prolonged examination exercise concludes with an air of uncertainty. But there is no doubt that candidates put in a tremendous effort in preparing for the exam. It must not be forgotten that even the examination authorities put in equally great efforts to successfully conduct an exam. There are the candidates who have successfully participated in the examination and the examination authorities. The present appeals are classic examples of the consequences of such interference, where there is no finality in the results of the examination even after lapse of 8 years. Apart from the examination authorities, even the candidates are left wondering the result of the examination, whether they are passed or not, whether the result will be approved or disapproved by the court, whether they will get admission in the college or university or not, and whether they will get into the draw. This uncertain situation does not work to anyone's advantage, and such a state of uncertainty results in confusion being worse confounded. The overall and larger impact of all this is the topic in the service. Nonetheless, then finally, in para 16, he knew the law about labor levis code. It is not open to the division bench. And in para 16 notes, I emphasis applied by the notes. In view of the above law laid down, it is not open to the division bench to examine the correctness of the questions and the answer keys to come to a conclusion different from that of an expert committee in its judgment dated so and so. The reliance was placed by the appellants on so and so. And the said judgment disposed indicates the selection should only have obtained the opinion of an expert committee, but did not enter into the correctness of the questions and answer for itself. Therefore, the said judgment is not relevant for adjudication of the disputed question. That's something. The reason of the above judgment is very clear that courts should be slow in interfering with expert opinion in academic matters. In any event, assessment of the question by the courts itself to arrive at correct answers is not permissible. The delay in finalization of appointments to public posts is mainly caused due to pendency of cases challenging the selections pending in courts for a long period of time. The cascading effect of delay in appointments is the continuance of those appointed on temporary basis and their claim for regularization. The other consequence resulting from delayed appointments to public posts is a serious damage caused to administration due to lack of sufficient personnel. So therefore, most my respectful submission is that once an expert has looked into it and given an opinion, let's look at the expert, we will place it on the record. Thereafter, again, my lords, the courts looking into that and finding fault with that question, my lords, would not arise as a respectful submission. Because here, a division bench of the High Court did that, and Supreme Court said it was not the correct way to go about it. One judgment of the Andhra Pradesh High Court. Judgment of the Honorable High Court. Para 1 minute. Original writ petition came filed to declare the action of the respondents in not allowing programmable calculators for paper 2 general aptitude and neglecting the mistakes that occurred in Telugu translation of at least 51 questions in paper 1 general studies and paper 2 general aptitude of group 1 preliminary examination. While a notification may be so and so conducted and so as arbitrary illegal and violation of Article 14. So, notice it was a preliminary examination similar to the one. Okay, this is para 11. Read it as it may. In so far as the error variation in translations from English version to Telugu version, the Honorable Supreme Court in Central Board of Secondary Education versus Rangarajan, the order is cited, dealt with a similar situation where there was very double translation of English questions in the NEET UG 2018 examination. Dealing with the same way, one of them stood in para 17 of the judgment held as under. In spite of this safeguard, it is proposed that in case of any ambiguity between the regional language and English, it will be the English version which will be final, as held by this court in the order dated so and so referred to above. At this stage, it is very much relevant to refer to the judgment of the apex court in Vikesh Kumar Gupta, just read the wherein the three-judge bench of the apex court observes that the practice of evaluation of among the questions by the courts with lack expert in academic matters should be deprecated. Then was the extracted portion I've already read. There are 13 minutes. The bench also observed that it is not open to the court to examine correctness of the questions and answer to come to a conclusion different from that of the expert committees. The apex court further held as follows. Then para 15 minutes. Further, the instruction number 3 in the first page of the question paper, the screening test itself clearly states that English question will be considered authentic question for evaluation purpose. There also it was the same question. Therefore, having regard to the judgment of the apex court referred to above and the instructions mentioned in the question paper, the variation in coming translation from English to Telugu will not be a ground critical in the screening test conducted. So it was under similar circumstances. Supreme Court relied upon Gandhadagudi and Vikesh Kumar Gupta and condition notes because of expert company report. So therefore, notes the fact situation is somewhat similar here. Fact situation is somewhat similar here. Notes in so far that they have cited two judgments. First one is in Prakash case notes of the Delhi High Court. Notes one more is Rahul Singh was cited by the senior, and Prakash Verma was cited by Pritish.
Cited it because it was a compendium of other judgments.
No, otherwise some observations.
And in 19 and refer
The notes have Prakash Verma notes. Notes have. In paragraph number 37, they refer to Himachal Pradesh Public Service Commission, and in paragraph 42 minutes, there is a finding. But the Delhi, this is by single judge bench notes of the Delhi High Court, where notes all the judgments notes according to the court notes which are relevant have been referred to. But they refer to notes one judgment that above paragraph is Himachal Pradesh Public Service Commission. And then paragraph 42 only, that is a finding, paragraph 42. The Supreme Court categorically held that the court cannot assume the task of the statutory authorities. As such, it is not permissible for the High Court to examine the question paper and the answer sheet by itself, particularly when the HPPSC has assessed the implicit merit of the candidates. Any discrepancy in framing of the question or answer of question, it was noted would apply to all candidates and not failure to respond number one. The Supreme Court observed that it was purely a matter of chance that the paper before the High Court was one relating to law, and that it had been one and that it had been, if it had been one relating to physics, chemistry, it would be doubtful whether the High Court would have embarked on the exercise of itself assessing the correctness of the answers provided by the respondent number one. Therefore, other judgments are cited, even Ranvijay Singh has been cited, and Ranvijay Singh from the other judgment is being cited. And finally, the dynamic front read that I would respectfully submit that this is a judgment notes passed by a single judge notes of a Delhi High Court. And I have cited notes the Supreme Court case on the point that is in so far in this Nikesh's case notes that I cited. So therefore, it is not that the court will not go into that. In fact, the final takeaway that the courts have said, it is not that the judicial review notes cannot be gone into, but how it has to be gone into is what I am saying. And the expert will refer at that. Court can refer if they have not already referred, if they have referred. So therefore, in so far as these principles is concerned, notes, I would respectfully submit that the judgments that I have cited of the Supreme Court in Gandhadagudi case and Nikesh's case notes will cover the case on hand notes on all its course. And this judgment notes where I think there has been an analysis of all the other cases. Certainly, I am not saying, sir, we are not saying the petition is not maintainable. Judicial review is there. There are cases there. But how to go about it in what is. So therefore, if court had it out, experting refer ಮಾಡಬೇಕು. Experting ನಾವು ಮಾಡಿಬಿಟ್ಟಿದ್ದೇವೆ. So experts corrected ಮಾಡಿದ್ವಿಲ್ಲ, that is what my lords have to go into. So question ನೋಡ್ಬಿಟ್ಟು ಅದರೊಳಗೆ fighting ಕೊಟ್ಟರೆ I would respectfully submit. Not due respect, lords, they are trying to highlight certain things, and even that also they were not able to highlight. Even they are saying that so many translation errors are there. What was your objection in the first place? Question and answer because it is like this. That reading unfortunately lords is missing, and only one person has filed objections according to their admission. Right. Towards next statement that was cited was the first in the first when Rajgopal sir had cited UPSC versus Rahul Singh was cited.
See in page number 72 in the Om Prakash judgment, it has been referred.
But in fact, it is.
But the details are not very published.
Starts at paragraph 67, internal page 29 of Om Prakash judgment.
Details they are not given details. So they are judgment.
But still, Rahul Singh was cited.
67, 68, 69.
Para 37 ಅಲ್ಲ, the details of that, Om Prakash.
Decision.
ಅದು judgment ಆಗಿರ್ಬೇಕಾದ್ರೆ.
Rahul Singh was first cited.
Rahul Singh,
Has been extended.
based on the Kanpur University case, Supreme Court judgment has come.
Has been,
22 days as circumstance approach. Still, that is the takeaway.
and therefore was clear even in that the takeaway is that the conflict in view and the court on what is opinion of experts. Right?
Basically.
Same thing.
Same thing. In fact, whatever judgments they have cited, that's in fact demonstrate that the process that have adopted. Rahul Singh, because I will just read para 12 minutes. Para 12 minutes. The law is well settled. The law is well settled with the onus and the candidate to not only demonstrate, so this was the onus on them, that the key answer is incorrect, but also that it is a glaring mistake which is totally apparent and more inferential process or reasoning is required to show that the key answer is wrong. The constitutional courts must exercise great restraint in such matters and should be reluctant to entertain a plea challenging the correctness of the key answers. Then, I will skip the Kanpur University observation. Next, paragraph 13. As far as the present case is concerned, even before publishing the first list of key answers, the Commission has got the key answers moderated by 2 expert committees. Thereafter, objections were invited, and a 26-member committee was constituted to verify the objections. And after this exercise, the committee recommended that 5 questions to be deleted, and in 2 questions, key answers be changed. It can be presumed that these committees consisted of experts in various subjects for which the examiners were tested. Judges cannot take on the role of experts in academic matters unless the candidate demonstrates that the key answers were patently wrong on the face of it. The courts cannot enter into academic field, weigh the pros and cons of the argument given by both sides, and then come to the conclusion as to which of the answer is better or more correct. In the present case, we find that we did a long process of reasoning, and the High Court itself has noticed that the stand of the Commission is also supported by textbooks. When there are conflicting views, then the court must bow down to the opinion of experts. Judges cannot be experts in all fields, and therefore they must exercise great restraint and should not overstep the jurisdiction to accept the opinion of experts. In view of the above, we are clearly of the view that the High Court overstepped the jurisdiction by giving the directions which amount to setting aside the decision of experts in the field. As far as the objection of the appellant Rahul Singh is concerned, after going through the question on which he raised an objection, we ourselves are of the prima facie view that the answer given by the Commission is correct. So therefore, most first, in fact, they had to demonstrate. Now, I had these questions. Because I attempt ಮಾಡಿದ್ದೀನಿ. ಇದು ಮಾಡಿಲ್ಲ. ಈ question ನನಗೆ. It is an individual grievance at the end of the day. It is not a public interest litigation that you come and just make certain allegations, press reports, Indian ತೊಂದರೆ ಆಗಿದೆ ಅಂತ you have to be able to demonstrate. And even in this case, Supreme Court said Rahul Singh's individual grievance was verified with regard to that question. And not we are to private the answer given by the Commission is right. Correct. So, if they are not filed objections for the Commission in the first place, and they have not challenged the key answers, they now come and make a grievance notes of the fact that there are translation errors. Maybe they got to know of the translation errors only from the papers. I mean, example of Bardmele. I'm just.
ಅಲ್ಲ ಪೇಪರ್ಗೆ ನಮ್ಮ ಮೂಲಕ ಗೊತ್ತಾಗಿದೆ.
ಅದಲ್ಲ ನೀವು ಪೇಪರ್ ಬರ್ದಿದ್ದೀವಿ. I'm just ರೈಟರ್ ಪೇಪರ್ ಬರ್ಬಿಟ್ಟು ಆಮೇಲೆ ಪೇಪರ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಎರರ್ ಬಂದಿದೆ. ನಾನು ಬರ್ದಿರೋ ಪೇಪರ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಎರರ್ ಇದೆ ಅಂತ ದೆನ್ ಮೇಬಿ I'm just
ಬಹುಶಃ ಕೋರ್ಟ್ ಬಂದಿದ್ರೆ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಪೇಪರ್ ಗೊತ್ತಾಗಿಲ್ಲ, ನಾನ್ ಪೇಪರ್ ಹೋಗಿ ತಪ್ಪು ಅಂತ ತೋರಿಸಿರೋದು, ಆಮೇಲೆ ಕೊಟ್ಟೆ ಗೊತ್ತಿರ್ತದೆ.
You are not influenced by a system. Papers are influenced by our.
Today you have filed a press. Today you are dependent on the newspaper.
Independent upon the newspaper with a statement of the honorable chief minister given in the floor.
Except for one candidate which you showed that
application for 4 years.
None of the applicants have filed any this thing.
No, that is, they have not even stated that I have filed. That is what I am saying. Because I have lot of object, I'm making that statement from their pleading. My lords will see. Application ಅಲ್ಲಿ ನಾನು objection file ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಲ್ಲ.
Only 686 applicants to 89.
Said up-
They have stated that they have filed 4 objections. In another, the other applicants have not filed any objection.
them.
But they have not pleaded also that I have given.
Not, one thing I would like to.
ಇಲ್ಲ,
ಇಲ್ಲ, ಅಂದ್ರೆ ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಆಮೇಲೆ ಹೇಳಿ, ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
Right of replies. But the last point was on the legal aspect, because much was canvassed on this aspect on the last date of hearing, because I just wanted to place it on record with regard to the state government.
And Kumar, you say this.
Yes, earlier I pointed out, because this was a judgment where not in respect of AW recruitment, the state had accepted the decision of the commission, decision of the KIT, and the commission decides to challenge it. Point number 1 was, and if my lords may have paragraph number 20. I'll read only regarding point number 1, that is locus standi. Point number 1, the bottom of the page. In paragraph 20, there are given 4 questions. It is regarding question number 1. Point number 1. Locus standi of KPSC. Whether the KPSC is locus standi to challenge the orders of the Karnataka Administrative Tribunal when the government has accepted its decision and seeks to implement the same. So this was the context for us. Then what's paragraph 23 constitutional provisions are extracted. I will not read that first. I will just there are 23 my lords can open constitution. Then paragraph 24 words, I'll just read it. Supreme Court judgments have been extracted with regard to the status of the commissions. Apex, in the case of state of UP versus Ravi, dealing with the functioning of the Public Service Commission as read as under. The commission is an independent expert body. It has to act in an independent manner in making the selection of prescribed norms. It may consult the state government and the High Court in prescribing the norms for judging the suitability of candidates with no norms fixed in the rules. Once the commission determines the norms and makes selection on the conclusion of the competitive examination, submits list of the selected candidates to the government, it should not revoke the selection by lowering the norms at the instance of the government. If the practice of revising the result of the competitive examination by changing norms is followed, there will be confusion and people will lose faith in the institution of the Public Service Commission and attend selection. Here is the opinion that the commission should take firm stand in this matter in making the selection in accordance with norms fixed by law or fixed by it in accordance with law, uninfluenced by the direction of the state government, unsupported by rules. Again, the apex code in the case of so and so held as under. The Public Service Commission is a body created in the Constitution. Each state constitutes its own Public Service Commission to meet the constitutional requirement for the purpose of establishing its duties under the Constitution. Appointment to service in a state must be in consonance with the constitutional provisions and confirm the autonomy and freedom of executive action. Article 133 of the Constitution imposes duty upon the state to conduct examination for the appointment to the service of the state. The Public Service Commission is also required to be consulted in matters individually in section 133. While going through the selection process, the Commission, however, must scrupulously follow the statute rules of operating in the field. It may, for certain purposes, for example, for the purpose of shortlisting, it can lay down its own procedure. The Commission, however, must lay the procedure strictly in consonance with the statute rules. It cannot take any action which would persist with the violation of statute rules and make the same inoperative for all intents and purposes. Even for the purpose of shortlisting, the Commission cannot take any kind of cut-off norm. Again, in the case of state of Punjab versus Manjit City was held as under. The Commission derives its powers under Article 320 of the Constitution as well as its limits too. Independent overworking of the Commission is of utmost importance. It is also not supposed to function under any pressure of the government as submitted on behalf of the Applicant Commission. But at the same time, it has to conform to the provisions of law and has to abide by the rules and regulations of the subject and to take into account the policy decisions which are within the government of the state government. It cannot impose its own policy decision in the matter beyond its purview. And paragraph 65 plus. Therefore, The Public Service Commission is a body created under the Constitution. Each state's constitution is responsible to meet the purpose of establishing the rules of the Constitution. The Commission derives its power under the mandate of the Constitution as well as its the Commission is an independent expert body. It has to act in an independent manner in the making of selection of the prescribed norms. Independent development of the Commission is of utmost importance. It is not supposed to function under any control of the government. Appointment to service in a state must be in conformity with the constitutional provisions and in conformity with the autonomy and freedom of executive action. While going through the selection process, the Commission, however, must seriously follow statutory rules of duties. The Commission, however, must lay down the procedure strictly in conformance with the statutory. The Commission should take firm stand in making the selection in accordance with the norms fixed by law or prescribed in accordance with the law uninfluenced by the direction of the state government and unsupported by the rules. So finally, my lords, in paragraph 27, you said, my lords, that the Commission in paragraph 28, it was said the Commission and local standing. Though, my lords, there was opinion between the Commission and state government. So therefore, my lords, this is the state. And in fact, my lords, from what has been reported in Rights of India, in fact, this is the laws also that has been reiterated by the Honorable Chief Justice of the Floor of the House. That Commission is an independent constitutional body. They will take their own decision. Stay here. And so therefore, banking too much, I will respectfully submit. If you had a case, well, first you had to argue your case. But on the last date, I took serious objection to the fact that at every submission that was being made, it was an attempt to defer the proceedings. That was on the premise that you are attacking my statement of objections instead of making out your case. I understand as a public authority, what I state, whether I am for a state or for any other public body, my stand notes, they can directly attack that. There is no doubt about it. But the fact that they have to make out their case notes is also important. Just to conclude my submission, in this case, we are so far as I will just put it out this way, so far as confidential matters is concerned. After the Hota Committee report was accepted by the state government, amendments of body, and now one more amendment has been introduced, which is that has been placed. I think it was placed before the House. A separate office was created called the Controller of Examinations to be appointed by a direct IAS candidate. So far as he was made the custodian of all confidential matters relating to the examination process. And even there is, it states that anything pertaining to the examination process, once the examination process commences, the controller of exam, we have the commission. The commission consists of the members of the commission, including the chair. Then we have a secretary, who is also an officer posted by the government. The secretary, earlier we had the commission and the secretary. A new office was created called the Controller of Examination, and he was given in charge of all the confidential matters. Now, there is also a rule which states that so far as sharing of confidential information, even with the chairman and the secretary, the Controller of Examination has to share confidential information only on a need-to-know basis. That is the rule. Need-to-know basis, even with the secretary of the commission as well as the chairman of the commission. So therefore, why I am setting it out is this: they have been saying they are wanting to see the records and other things. Suppose, my lords, if I make the facts public with regard to the process I adopt of how I set my question papers, how I choose my experts, if it goes into public domain, then my lords, let me imagine what kind of efforts could be made tomorrow to try to contact them and all these things. So therefore, the process has to be confidential. We are not averse to placing anything before this honorable court. Anything, my lords, whether oral direction or written direction, we will comply with the orders of the court. But at the same time, I cannot, the confidential thing, I cannot, maybe the council can, if they want to have a look at the records based on the court's discretion, they can have a look at the records and make some submission. But at the same time, it cannot be that I give it to the petitioners, I give it to the applicants. The process is confidential because tomorrow I follow the same process. The experts who tomorrow also I might go with the same experts. So therefore, the persons who man them, who are the experts, who are the paper setters, all this is confidential. And only the Controller of Examination knows. Even among in the KPSC also, that was the reforms that was brought about notes in the earlier notes based on the accepting certain findings notes of the Hota Committee report. So insofar as the expert opinion is concerned, Because I have a sheet of notes which contains the opinion of the experts in respect of the 67 questions notes with regard to translation. There is also a separate report notes with regard to other questions also. All the questions, 61 questions that were in question, including the questions in respect of which notes they have opined. I have. But below that notes, everybody's signature was there. Right now, notes what we have done is I can even produce the signed copies also before the notes, but that will contain all the names and everything. Now this one, we have redacted the signatures and the question finding everything is there in this report notes. Notes may have to be in anything further notes, any record is required. Notes will be able to place it before the board. We can also place it in a sealed cover if my lords, in fact, want it on the purpose of the court, because we as a constitutional authority lords have an obligation to justify the process. But we have
Necessity will ask it now.
Please.
Yes, kindly.
Please. So therefore, notes, I conclude my submission. The notes may, this is the petition notes which is liable to be dismissed. They have not notes even met the threshold bar notes that is required to make an interference, and they are only trying to not rely on certain other things. And I would say notes to come out with a petition like this. I understand notes they are not qualified for the main examination, so therefore there could be every attempt to make. But I also kindly see in public interest perspective, Supreme Court has said this kind of litigation will not lead to uncertainty, delay in making appointments. So expert opinion is taken. So therefore, in my respectful submission notes, it is a case for dismissal. Grateful. Yes.
But the substantial quantum of argument was addressed. And that the expert committee submitted a report, they notified all those things. That it could not take it. I was very handicapped to say anything about that because either it is elaborately treated in a objection, at least with reference to what is that expert committee, who are that expert committee, how many questions are referred to the expert committee, what is their report, what will be the ultimate decision of the commission. All these things are concerned, pre-English totally lacking. By lacking and putting us in dark, your lordships call upon anybody to answer what is your say. I'm not able to answer, sir. I'm not insisting that KPSC to show me your all document. I wanted to instruct it is not given. At least you have been provided material particulars in your counter to the effect who are the experts. Whether they have a doubt whether they are the experts or not. And our limited scope of argument, all these aspects, what I learned AIT senior courses, I'm not including the particular law. But before going to that, have you an attention to look into that or not? How could you look into either we could look into the material on our own, or we should be guided by the pleading made by the others. If the pleading is lacking all the material particular and calling upon me to answer, when I see it is they made me handicapped to answer, I could not able to answer. It's ultimately what is called, we go to the root of Article 14 only. I'm not insisting for what it may give me the set of paper, who are the expert, what expert report, how it is, and ask them to give the note sheet of the KPSC. We are not asking, we know our limitations, we know our boundaries. But let us see the pleadings where I read it again, is it provide any material particular? Suppose we are in their office of MA or MK people say, they constitute their committee of their own officials, get a report. If they call them as an expert, how could they? This is one aspect of the matter. The second aspect of the matter is that quantum of objection would not be the determining factor so far as fairness and reasonableness in relation to a discharge of a public duty is concerned. The quality of the counter is important. It doesn't mean that all 55,000 candidates who detail answers to Kaida, they should lodge a complaint before the KPSC alleging that there's a translation. We are do this judicial interference. It is not in the hands of the conservative judicial person. Now the rational judicial interference is making a revolution in our country. It is not only in respect of property right, with respect of public right, or in respect of a service matter, whatever it may. This is the flow of our judicial devolution or evolution. Therefore, my lord, admittedly there was a complaint. Complaints are serious in nature. It is not, KPSC not admitting. Honorable Chief Minister said, yes, we are shameful to see that, he said. Today's newspaper is. Then he suggested a committee to be constituted to amend this rules itself. There are one more
That
information.
would be in prospective. That will give effect only in prospective. Only because of if any amendments, that will not help to the applicant's hearing.
What is suggested by the Honorable Chief Minister, they draw inference could be drawn about the gravity of the issue in question. That is my submission. But further, Honorable Chief Minister went on saying that we wanted to blacklist all such examination experts who are involved in translation. No, this is not said by me or somebody else who is wandering on a street. Honorable Chief Minister made a statement on the floor. There our representatives were there. Then my learned friend said something about secrecy and other things. Can I mention one issue? In between 1950 to 1993, there are about 87 governors who have been proclaimed as innovative articles in the out of which 10% were challenged before the Judicial Forum. Up to 1993, it was the opinion of the court saying that any report submitted to intercept between the governor and the President of India, when it is approved by the Parliament, it would not be amenable at least to be seen and examined by the court. That was the situation. He did not kill pronouncement of judgment in Bommai's case. But in Bommai's case, Supreme Court said no. We wanted to see that to the little extent. We want to see what is the report. It was a judicial revolution. Now my learned said, what is secrecy? He said in military issues that issues relating to what? Who invited applications? We are the candidates. We are the aspirants of the employment. We have dismissed status for the eligibility. We attended the examination. In the examination, some degrees have been passed to us. This is our comment. What is your answer? Yes, it is degrees. You say it is not happened. I have got a report. That report says it is not there. But in this process, it is secrecy. I can understand whether in that matter, I would like to refer it. In Goyal's appointment to the Election Commission, the very stand was taken by the Union of India. A person retired 24, and in a expiry of before expiry after 24 hours, Goyal was appointed as one of the commission to the Election Commission. Then one of the judges in the Supreme Court was hearing the Constitution to a lawyer representing the Union of India as well as Election Commission. I want to see the file. Then when the Union of India said, no, file need not be placed. Then Supreme Court said, you keep your file with you. We draw an adverse inference. Within a 24 hours, you will personally allow X to return IAS officer. He has got 1.5 years of service. Even expiry of 24 hours to make an election commission. In a speed, such a speed, you take on a decision. And if you don't want to see the total file, we don't want to see your file. I know what is there in the file. You don't pollute us by seeing the file. It is besides language that is implied by the Constitution, of course. We don't want ourselves be polluted by seeing your file. Then the central government passed on that. Ultimately, what happened? Appointment was cut down. We are in a rational state, It is not the limited scope of judicial scrutiny, it goes in certain extent, not in respect of all matters. Therefore, my lord, my submission is, it is not need for us to tell us. At least issue the papers. It has been seen by your lordships. Then we could have been asked, sir, we have seen this. So and so are the experts. We don't want to tell all the, we don't want to allow you to see the file. Don't follow us. We are not.
whatever get what is the outcome of the opinion of the experts has been disclosed before the trailer
For the
and made it known to the applicants.
My lord, yes. But ultimately, my lord, the expert decides who said. Is that decided the fate of your lordships? No. Are your lawyers here appearing the parties? No. Ultimately, their fate is decided by the expert. And I make it clear, my lord, as with all responsibility as a senior counsel, I am not insisting or I am not intending to see their original file. But at least their file should be satisfied to your lordship's conscience. Yes, there is a transparency in taking decisions. Okay. We agree with your lordship. We agree with your lordship. Even it is also not placed before your lordship said, your lordships have been made handicapped to put any question to the bar on that aspect. Till I complete my argument, I wanted to say, the fairness is lacking in decision-taking process. Now fairness is lacking even in judicial process where we are arguing the matter because we kept it on and argument was settled. That's all the reply, my lord, I wanted.
I take what 10 minutes, it's 2:30 today. Later, I thought
Maybe
it's complete.
Complete concept.
Like to-
That's exactly right. I'll go point by point. I'm sorry, I'll have to ask your lordship to shuffle the papers, but I'll be very, very precise. Let's learn it. Senior counsel for the KPSC started off with the method of examination. Would your lordship just have that rules page number 9, because question papers have to be set, was read out to your lordship.
Application.
Right. Undisputedly, my lord, the arguments before your lordship, my lord, annual on translation from English to Kannada, whether they are right, wrong.
Suppose there is a re-examination and again this happens, then what happens? There is no finality
I
to
take
the
the lordship.
KPSC.
My lord, I take a
So this KX exam should be taken by. No, I'm just asking.
But I tell your lordships how it will not happen again. But because the material lordships, and I'll point out how. But if your lordships were to see the first time an exam happened and this time, the question paper. Sorry. The new scheme of examination.
We continue. We have seen it. We will know now. When we go ahead, it is already too late.
Yes.
In schedule 2, what was
686.
yes. The rule, the gifted professional rules. Yes. Like schedule 2, note 1. The text, my lord, in my respectful submission is very, very clear. Note to schedule 2. Yes. The question paper shall be set both in Kannada and in English. Question papers have to be made in Kannada and in English. The rules does not say question paper shall be set in English and translated into Kannada. No, my lords, it is admittedly the case before your lordship that the question paper was only set in English and translated to Kannada. That is where, my lords, the mistake and the problem has arisen before your lordship, both in the first time and the second time. If the question papers were simultaneously set in Kannada and English, this would not be, my lords, the problem. And if paragraph number 16 of Rangarajan was followed, that was in 2019. Malad, this mistake would have been prevented. I'll point out, Malad, what the objections were and what has happened. Right? I think the rules have to be given some primacy when they say it has to be set in both languages, not set in one and translated to the other. Now, Malad, I'm assuming, Malad, translation to the other language is also setting of a question paper in the other language. Then, key answers must be available for both languages. Key answer is available only for one language. You have not published key answers in both languages. Malad, it was there.
In key answer, there is only ABC.
No. If it is translated, there is only one. If it is set in both languages, key answers will be different.
No, I just want to know. Key answers is only ABCD. No?
ಅದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲ
ಹಾಕಲ್ಲ.
ಅಲ್ಲ ಅದು ಕನ್ನಡದಲ್ಲಿ ಅದೇ ಪ್ರಶ್ನೆ ಇದ್ರೆ ಆಗುತ್ತೆ. ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅಲ್ಲಿ I point out how much. The second argument was rather the contention of the respondents was not on the case of the applicant but as against the applicant, which is not needed, they are not made objections, so on and so forth. Now, all skills of advocacy are presented before your lordship, but please examine it in this aspect. Objections were called for the provisional key answer. Now, the paper setter or the expert committee came, read the provisional key answer and said, this is the key supposed to evaluate your question papers on. We filed our objections. Now, Malads, the objection for your lordships, Malads, is not only to the key answer but also to the translation in question. Now, please kindly have, Malads, this notification dated 3/2/25. Today, Malads, I got this. I'm sure, Malads, it was given earlier when I was not there, but anyway, it plays before your lordship. Just have a look at the notification itself. Notification categorically says we called for objections to the key answers. The expert committee took a decision on the key answers, not on the mistakes in the translation of questions.
See, tell us one thing.
Yes.
What is the end result? You should be able to answer by reading the question.
Correct.
So the answer itself, see what are you objecting to?
Yes.
Because the question was not properly worded, I could not look into the question. That is the
One
grievance.
aspect of the matter.
That is a grievance.
One
That is
aspect.
only grievance. No, that I could not read the question properly. I have not answered to my fullest capacity. What else is the
Yes.
reason?
That when the question itself is wrong, there are three things that can happen.
Question, you have never said question is wrong. You are saying only translation is wrong. There is a difference.
The question in Kannada is wrong.
Question in Kannada wrong and translation wrong. There is two different aspects. Because the translated word meaning will change. Like which you read, I think
Yes.
somebody read
Yes.
about Sita and other things.
Yes.
The meaning changed.
Yes.
In the only thing is that they were not able to answer because they could not understand. That is the only thing. No.
May I put it this way? Yes, that is one of the consequences. The other consequence is if the translation itself is wrong, the answer itself changes. Like, can you demonstrate? Can I just demonstrate?
See,
Yes.
question number 21 yesterday you read.
Yes.
Read that only because question number 21 they have said it is wrong and you got a grace mark.
Can I don't think they have given grace mark for that. Anyway,
21 they have given.
yes. Malad, can I just point out, Malad, in my application 686. Malad, your artist may have this sheet, Malad. There are two things that I want to point out. Just the notification dated 3/2/25. And page 202 of my application 686.
You have given so many papers.
I'm so sorry, Malad. I understand. ಇದು ನೋಟಿಫಿಕೇಶನ್ ಅನ್ನು ಕೊಟ್ಟರು ಅಂತ
ಇದೆ. 686.
Question paper 686 page 202.
In the question paper,
It's a question paper.
Question paper. page 202. Would your lordships also have this? Just to, I'll point out what exactly my case is.
reply statement. Reply statement. Chief Secretary resolution ಮತ್ತು ಅದು ಆಜು ಬಾಜು reply statement. Annexure R2 in application number memo with
Respond.
563 10 to 2005 common application ಆದ ನಂತರ immediate ಆಗಿ IAO
Your lordship got both.
Yes.
Can I read 202 the question in English? Question in Kannada. What is the marks awarded? Because apparently this went to the expert. It's 202. I'm just pointing out one. 202. Bottom left, 54 page number. The lordship got.
Yes.
In the first table, serial number 4 minutes, that is in paper B, question 54. That's exactly what I'm pointing. Well, I'll read it in English. To travel from Karnataka to Mizoram by walking, the minimum number of states you have to pass through would be excluding the origin and destination state. 3, 4, 5, 6. That's, I have to tick one of them. Mainly, ಕರ್ನಾಟಕದಿಂದ ಮಿಜೋರಾಂ ನಡಿಗೆ ಮೂಲಕ ಪ್ರಯಾಣಿಸಿದರೆ ಎಷ್ಟು ರಾಜ್ಯಗಳ ಮೂಲಕ ಹಾದು ಹೋಗಬೇಕಾಗುತ್ತದೆ? The minimum number of states, my lord, is the question in English. Kannada minimum ಅನ್ನೋದು ಇಲ್ವೇ ಇಲ್ಲ. My lord, if there is ambiguity, I will refer to English. But to me, Kannada is very, very clear. ಎಷ್ಟು ಅಂತ. Question itself is wrong. Now, please refer to the table that is given. Expert committee, my lord, says the answers can be 2, 3 and 4. Expert committee does not say that there is a variation in the question at all. And that is exactly what I'm pointing out before your lordship, that the expert committee has answered only insofar as he answered and not the question. And while your lordships are holding the table, my lords, serial number 4 has multiple answers. Table 2, serial number 1 has multiple answers. The objective of multiple choice question is that you tick one answer and not multiple answers. Now, my lords, that is also a settled legal position. I'll point out how. Now, just because I got this table today, my lords, I'll place reliance on 2 judgments where the judicial forums have taken a view that the moment there are multiple answers to a multiple choice question, the question should be deleted. It can't be taken into consideration at all. And the added circumstance is that there is negative
They are
marking.
being selected for an administrative post. They will have to take multiple decisions based on variables. So if they are not able to understand their question, how is they competent? No, I'm just asking you. See, there are, like if it is a SLCC exam, yes. They are young boys, 14, 15-year-old, they cannot understand. NEET also, young children. But here, they are all above 21. With a judgment, they are being selected for an administrative post
Okay.
where they will have to have multiple times, multiple variations of decision to be taken.
Yes.
See, what judgment you are keeping, I'm only coming to that. What judgment you are showing, are they related to competitive exam or for the SLCC?
No, competitive examination with multiple choice questions. Let me just put it this way. Let's, KPSC is a constitutional authority. Exam being conducted for serious responsible positions in the state. A constitutional body occupying such an exalted position under our statutes, my lord, prepares question papers in this manner, and that is sought to be justified.
Should they ask
Yes.
the applicants only to suggest their question paper?
I am not saying so, my lord.
You are saying
But,
so.
no, I am saying that some more, my lords, responsibility ought to have been exercised. Let me just go answer the question on multiple choices, my lord. I'm just relying upon two judgments, just the relevant paragraph. Since I got this today, otherwise I would have argued it, my lord, at the time of my main
This was
argument.
already given to them.
No, I was not there. Admittedly,
You are not the council on record.
correct. So therefore, I got to know today.
Yeah, before
He can't
the
stop.
commencement of the arguments on behalf of KPSC, you would have supplied.
I did not know only the arguments when I got, and I specifically.
Okay.
I specifically.
We'll give you an opportunity. Let it.
Well, your lordship, it's ultimately left to your lordship. Would your lordship straight away come to para 8, my lord? Internal page number.
Supplement copy.
I have given them. Please they are given. Internal paragraph number 8. At what stage this is being given is the objection. But the objection is not that what we have done is correct. Just have a look at para 8, my lord. Salim Maheshwari Supra also dealt with the question of re-evaluation and has concluded that the question, I'm sorry, internal page number 5. Your lordships have the judgment in Sumit Kumar.
Yes.
Yes. Para 8. Salim Maheshwari also dealt with the question of re-evaluation and has concluded that the question of re-evaluation does not strictly arise when the examination comprises only multiple choice questions. The reason being that multiple choice question test is premised on the basis that there is only one objective correct answer to every question. The system of multiple choice objective test, type test, and the scope and ambit of judicial review has been examined in so and so. In Salim Maheshwari, after referring to the above quotation from Kanpur University, it was observed the very finding that the key answer is not objective single correct answer of the 4 options provided, and that another answer is correct, according to those well-versed in the subject itself, would merit the awarding of additional marks to the candidates who had chosen the latter answer. There arises the need to evaluate or examine the response of the candidate for the second time since all so on and so forth. Now, my lord, therefore, my lord, they said that multiple choice question para 8 can be premised on the basis that there is only one correct answer. My lord, and this was in respect of recruitment to judicial services. Let's kindly see the earlier judgment of the Punjab and Haryana High Court.
See,
Only-
if you look at the UPSC preliminary question, they give very difficult questions there.
Yes.
They say 1 and 2 are only correct, 2 and 3 are only correct, all are correct, like that.
There are 4 options,
No,
and
there
only
is
one
no-
option is correct.
They give like this, all the statements are wrong.
Yes, ma'am.
Only 1 and AB are correct,
Correct.
1 and 2 are.
I have
These
to say-
questions, tell us, where the applicant was put to test in this question which you just now showed us.
Yes, ma'am.
Multiple choice question, we show us that question which you are having a problem.
202, ma'am.
Do not.
You,
Yes, sir.
while we have to, when you are arguing on the question number 54,
Yes.
and
No, I
you have to
say,
take instruction number 7 of the rules. of
I'll
KPSC rules.
just come to that one. I'm aware of that.
Because you have spoke to read both Kannada and English
Yes.
while marking the.
Correct, ma'am. I will refer back to condition number 7. Provided there is ambiguity. Now, my lord, I have read only Kannada. The question is, what is the minimum number of states on the Bilvela? Kannada, how many states do you cross by going from Karnataka to Mizoram?
ಇಲ್ಲ ನಿಮ್ಗೆ ಎನಿ ambiguity ಇದ್ರೆ if any confusion found during the time of marking the answers in names it.
Kannada is very clear.
ಹಾ
Kannada is very clear in saying how many states do you cross by traveling from Karnataka to Mizoram. But in English, it is what is the minimum number of states. When I answer in Kannada, minimum illa, ಏನು confusion illa, minimum ತೆಗೆದ್ರು answer, it is capable of being answered. But in English, if it is minimum, the answer is entirely different. Just have a look. ಕರ್ನಾಟಕದಿಂದ ಮಿಜೋರಾಂ ಹೋಗ್ಬೇಕಾದ್ರೆ ಎಷ್ಟು ರಾಜ್ಯ ದಾಟಬೇಕು? Very simple. 3 ಕೊಟ್ಟಿದ್ದೀನಿ. In English, the question is, what is the minimum number of we cross? For that, they say 2, 3, and 4 is the answer. I will not even refer back to English because there is no ambiguity in Kannada.
There is no one pada missing ಇದೆ ಅಲ್ಲಿ.
ಅಲ್ಲ, ನಾನು ಇಂಗ್ಲಿಷ್ ನೋಡಿದ್ರೆ ambiguity ಅಂತ ಗೊತ್ತಾಗೋದು. ಕನ್ನಡ ಸರಿ ಇರ್ಬೇಕಾದ್ರೆ why did I refer to English? And please consider,
See, 1 minute. In this exam, you have not given a choice whether I'll give exam in English or Kannada.
correct. That is exactly what I am saying. What they have done in that instance is that if I have to refer back,
For that, only Kannada question paper will be given to Kannada candidates and only English will be given. Then the bilingual will not come to you.
that is exactly what I am trying to tell.
You all want to take exam only in English.
Can
I'm just asking.
I'm not taking. When somebody is answering, neither does KPSC know, nor does anybody else know which questions are referred to. Therefore, the onus is on the authority to set the questions right. It is not on us, my lords. Today, I see what your lordships are putting to. You are the candidate. How did you refer only to Kannada? But I am answering 100 questions in 120 minutes, 72 seconds per question, and your lordships are asking me to differentiate between Kannada and English before answering.
It's just side by side.
No, but why should I read it? Then forget Kannada. Why do you even have questions in Kannada if you have to always go back to English?
Don't get emotional on
Right,
this.
I'm not getting emotional, but that's practical answer.
We are just asking you for our own clarity.
I'm so grateful.
What are you coming to? That is what we want to know. You want
Yes.
again the expert committee to look at all 61 questions.
No. What
You are saying that all 61 questions have not been referred by the expert committee. Let them look at all of them. This is what you are asking.
Malak, that is not.
Because you are saying 54 has not been put there and
54
another.
is put. 54, what they have done is, they have said multiple answers are correct. They have not said the question itself is incorrect. There is a difference between the two.
This understanding because they are not finding any problem in the translation. So that's why they have said.
That is exact.
So I want to know what is your coming to.
Malak, can you-
That expert committee, you said in the beginning of your argument that some of the questions which were also referred to has not been put in the expert
Correct, that is
committee.
exactly what
What is your submission?
Malak, my submission.
At
Yes,
2:45.
Yes,
you
I'm
should-
just taking 2 moments.
Yes.
Malak, it's only this. The expert committee has said, in English, this is the question, these can be the answers. The expert committee did not say, the question in Kannada is entirely different. English is minimum state, so ಕನ್ನಡದಲ್ಲಿ ಎಷ್ಟು ಸ್ಟೇಟ್ ದಾಟ್ತೀರಾ ಅಂತ ಕೇಳ್ತಾರೆ. If it is
ಆನ್ಸರ್ ಮಾಡ್ತೇನೆ.
before that, can I just say, in that, I just read that sentence up here. Thus, they have just said, Malad, where they said that in an MCQ question, if there are multiple answers, that itself requires the consideration of the court. Malad, the other argument, Malad, on the Supreme Court judgment is 2019. It is not my argument that all questions require judicial review. But where they are patently erroneous, the jurisdiction of the court, Malad, is not completely barred. Your lordships will exercise it with some circumspection. That's all. It is not barred. Malad, in a case of this nature where the questions are so different and expert committee says, insofar as key answers, this is the right answer. But questions will forget about it. Malad, that might not be the correct approach, and when the questions itself are wrong. And I pointed out that export import question also. Question number 21. Yes, ma'am. Question number 21.
Yes, so far this question, the learned friend, I just answered that. That is not related to serial number 4.
Correct.
Key answers. Serial number 4 will get. I will get, we have changed the key answers from 2
2 or 3 or 4.
In the Kannada version, all 3 are correct. So therefore, and in the judgment that has been pointed out by in the Delhi High Court, paragraph number 9, in such a section number 9, what it says in the Delhi High Court judgment, that is Sumit Kumar's case, albeit in cases where the answer key is indeed incorrect or more than one key to the answer should be correct, the candidate should not be penalized for answering at variance with the key and none. So therefore, expert committee has considered this. He is presuming that expert committee key answer. Because answer means key. Because where is the answer without a question? There is. I asked myself this question. There is no concept of an answer without there being a question. You cannot look into the answer without looking into the question. One second. And because in so far as the reverse key answers is concerned, this question is where we have modified it from key answer 2 and 3 or 4.
Yes.
He has to say now whether his client has answered. We don't know for whom he is appealing. He just walking in that exactly.
Yes.
Allah, whether you have answered the question or not.
Please mark that statement, Malad. I am being negatively marked in the examination. If I answer, it's like holding a knife to my throat and asking me to laugh. You will be negatively marked if you answer wrong. But my question can be wrong. My question between English and Kannada can be completely at variance.
So, but you have not read English version. You have only read Kannada. Just asking. You have read only Kannada version.
Yes.
Now the key answer gives you 3 options. All 3 are correct.
That's my problem. It cannot, multiple choice questions cannot have. Malak, or A, B, C, D
That
can
is how
all
the expert committee has given you the list.
Malak, that's exactly what your lordships are testing today. Can the committee give A, B, C, D as all the correct answers? Then what is the point of having those questions?
See, you are saying
All the answers
I
are
will
correct.
not,
Then question need not be available.
I will not read English version. Okay. So the minimum pada illa. The minimum word is not there in Kannada, which just now you read.
Right. I may
So,
awarded
I mean-
grace mark for the wrong question. That's all. For the remaining wrong
Only
questions, they have
only grace
given
mark
grace
ಇಲ್ಲ.
marks.
Only grace mark ಎಲ್ಲಿ ಇದೆ? Other
ಅಂದ್ರೆ ಬೇರೆ question ತಪ್ಪು ಅಂತ grace marks ಕೊಟ್ಟಿದ್ದಾರೆ.
After giving the grace marks, whether the applicant sharing are eligible to.
That's why ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. Objection.
That I have already answered. I will not go back and re-agitate. But one more thing, my last memo. He is appearing for 3 of the applicants. 3 of the applicants, ಅವ್ರಿಗೆ ಆ question answer ಮಾಡಿ options ಮೇಲೆ answer marks ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ, what is the objection? Therefore, they are not going back to individual thing. ನಾನು ಇದು answer ಮಾಡಿ, they have their OMR sheets. They have their carbon copy. They know which answer they have. So basically, you have answered it. You have maybe got it or not got it. You cannot argue in vacuum. 3 ಜನ ನಾನು ಏನು ಆನ್ಸರ್ ಮಾಡಿದ್ದೀನಿ ಆ ಕ್ವಶನ್ ಫಸ್ಟ್ ಹೇಳಿ ಅದನ್ನ. He is conspicuously not citing all that fact and coming here and giving the quantification. Without due respect, and he is saying question. Whereas we are saying that it happens. Courts have been seeing the litigations where errors have happened. That does not mean that you cannot come and say that this is what I'm saying is if he is appearing for 3 people, he question ಏನು answer ಮಾಡಿದ್ದಾರೆ ಹೇಳಿ. Let him say.
One go. I have answered answer number 1. I am making a statement.
1 second.
I have answered question number 54 at serial number 1.
After
Question is wrong, give me grace mark.
After all
Let them
that-
answer that.
After all that matter is over,
He is asking me now, I am answering now.
I request the bench, kindly direct the advocates to address the bench, not to each other. It's my request. Please, it's my request.
I mean,
Both are my good friends. Please, ಅದ್ರಲ್ಲೂ ಪೃಥ್ವಿ ಒಂಚೂರು ಯಂಗ್ಸ್ಟರ್ ಸೀನಿಯರ್ ಇದ್ದಾರೆ ಆಯ್ತಲ್ಲ, ರೂಮಲ್ ಅವರು ಹೇಳಿದಾಗ ಪಾಪ ಹೌದಲ್ಲ, ಸ್ವಲ್ಪ ಸಿಂಕ್ ಮಾಡಬಾರ್ದು. ಪೃಥ್ವಿ ಅವರು ಸಣ್ಣ ಏಜ್ ಇದೆ, ಹೌದಲ್ಲ.
ಆಯ್ತು ಪ್ರಕಾಶ್ ಸರ್, ಈಗ 2 ನಿಮಿಷ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
ರಿಕ್ವೆಸ್ಟ್ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್. 3 ಗಂಟೆ ಆಯ್ತು, ಹೊಟ್ಟೆ ಅಷ್ಟು
ಆಯ್ತು, 2 ನಿಮಿಷ ಪ್ರಕಾಶ್.
ಸುಮ್ಮನೆ ಜಗಳ ಮಾಡೋದ್ರಲ್ಲಿ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಸರ್. ಪ್ಲೀಸ್ ಸರ್, ಇಲ್ಲಿ ಸರ್ ನಾನು ಕೋರ್ಟ್, ಐ ಮೀನ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಸರ್.
Now, Malak, the question is of interference with expert opinion will not arise is Malak one of the arguments. My argument is it is not interference with expert opinion. There is no expert opinion on these aspects. Please have a look at the notification dated 3/2. It is not interference with that. When there is nothing available on record that there is no expert opinion on this, then your lordship will step in and say that these questions are palpably, demonstrably wrong, and therefore, Malak, we will step in. That's my submission. That's question number 21 Malak is one thing, and question number 5 also.
Question number 54 you read.
50
And 21 you read.
5 ಅಲ್ಲ. Page 203 ಅಲ್ಲ, 54 ಪಕ್ಕದಲ್ಲೇ ಸೆಲೆಕ್ಟ್ ದ ಇನ್ಕರೆಕ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಪ್ಪು ಅಂತ, ಇನ್ನೊಂದ್ ಕಡೆ ಅದಕ್ಕೆ ಏನು ಗ್ರೇಸ್ ಮಾರ್ಕ್ಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಕನ್ನಡ ಅಂಡ್ ಇಂಗ್ಲಿಷ್ ಬೋತ್ ಕ್ವೆಶ್ಚನ್ಸ್. 54 on the right side. Select the next page. Select the incorrect statement about Lahore resolution. ಲಾಹೋರ್ ನಿರ್ಣಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತಪ್ಪಾದ ಹೇಳಿಕೆಯನ್ನು ಆಯ್ಕೆ ಮಾಡಿ. meaning itself changes. ಒಂದ್ ಕಡೆ incorrect, ಇನ್ನೊಂದ್ ಕಡೆ ಸರಿಯಾದ. That is not included in the key answer. At the 2019 judgment, what they said, how translations have to take place, if at all it has to be translated. Though it came in 2019, it's still not adopted.
See, there is a huge difference. There they were taking exam only in Tamil. 21,000 students took exam only in Tamil, and then there was a Tamil problem. Here, it is not the problem. That Rangarajan case is for the 21,000 Tamil students.
Here also.
Yes, because there the problem is of the translation. And only those people who even gave, they got benefits because of the grace mark. That's why everybody went against them. So that even if they had answered and the wrong thing, they got grace mark and they got above ranking. That is the problem in Rangarajan.
That is
I
what.
don't think Rangarajan fully can be covered in
Yes,
this.
if your lordship want to read para 5 of that, I'm not running, but para 5 Mother will answer your lordship's query on that. Irrespective of the methodology, when there are questions being put in multiple languages, please follow this method is what they say. And translation has to, this mistakes in translation they say has to be avoided.
Your questions are 54, 21 and 5.
5 and whatever.
I mean, we will not be able to read all the.
I understand.
But 11.
Compilation are put in.
Compilation is there, but we can't go. We'll go only for the which you read out to.
67.
Yeah.
Compilation is a part
No, that we'll see. But today, as a prayer, I mean, we are again asking 54, 21, and 5.
We are 61.
All 20.
Already they have marked already ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ mark ಮಾಡಿದ್ದಾರೆ.
We have marked. We have marked.
Mark
We have
ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಸರಿಯಾಗಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. Expert report ಆಮೇಲೆ ನಾವು ಡಿಕ್ಟೇಷನ್ ಕೊಡೋದಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ. Necessity.
That's what we are saying. In case it requires.
Necessity will directly
What if they can be pass an order to place that report before you are.
We have said that also.
What will decide the government? You can keep the articles.
We have already told
If
him.
the lordship wanted to put the report,
We have said.
again, I think your lordship have to see the report. That is the fundamental principles of natural justice.
Why are you saying against?
A judicial order, as the KPSC to place that report.
We are saying that. We are
to
saying.
heard further arguments on both the sides. And learned Sri Jacob Learned Senior Counsel for KPSC is directed to place the experts report in sealed cover to the bench and all and reserved for others. Whatever it is,
whichever.
I was attended till dispose of the applications. Next ಇದ್ದದ್ದು ಮುಗಿಬೇಕಲ್ಲ ಇನ್ನು ಎಂಡ್ ಆಗೇ ಇಲ್ಲ.
This is just one.
3 o'clock ಬಂದಿರ್ತೀವಿ ಇವತ್ತು. 3:30 other matters 3:30 ಬರುತ್ತೆ. ಇಲ್ಲ KM Prakash 3:30
ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ಆಗ್ಬೋದು.
ನಿಮಗೆ ತಗೊಳ್ತದ ಉಳಿದ 3:30
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
Come here, Ramji.
ಏನೋ ಸೀನಿಯರ್ ಹೇಳಿ ಸರ್.
ನಾನು ಆರೋಗ್ಯ ದೃಷ್ಟಿಯಿಂದ
ನಾನು ಹೇಳ್ತೀನಿ ಸೀನಿಯರ್ಗೆ ಹೊಟ್ಟೆ ಎಷ್ಟು ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ ಕೊಡ್ಲಿಕ್ಕೆ ಕೇಳೋದಿಲ್ಲ.